All right. Welcome, everybody, to the 2021 Journal of Law and Technology Free Speech and Social Media panel. I'm Kyle. I'm a Dev Director with JOLTT, and I'll be your moderator this afternoon. We are joined today by a fantastic panel of experts, and I'm excited to hear their input on this evolving area at the intersection of law and technology. Today, we have Professor and Academic Dean Bobby Chesney from the School of Law. We have Professor Oren Bracha, also from the School of Law, and Professor Amy Kristen Sanders from the School of Journalism and Media. Thank you all so much for being here.
Thanks for having us.
All right. So I'm not planning on running, a super tight ship. If you hear something that's interesting, feel free to jump in. I don't want this to be stiff or anything like that. We will have some time at the end for student questions. But before that, for you who all are on the panel, just like I said, kind of feel free to run with it. I will start out, though, with some questions that we fielded beforehand. And I think the first one that I'll ask is a pretty common topic of discussion that for some people at least has a pretty simple answer. Does the First Amendment, this is social media free speech, does the First Amendment apply to private companies that censor speech? For example, social media companies. And I guess just to kick it off, Professor Chesney, would you like to start?
Well, it applies to protect them from censorship imposed by the government, not to limit what they are doing in some fashion with their own property. They are, like us, beneficiaries of the First Amendment, not victims of it. So I'll sort of say that in as provocative a way as I can in an effort to stir up conversation. The idea that we often see, we know why this question comes up, because there have been instances of people either being deplatformed, blocked, removed, particular tweets or otherwise being shadow banned or yanked, what have you, or commented upon or framed. There's so many different things, and we'll have to talk about the nuances. And sometimes people who've been on the receiving end of these private entities acting on their content moderation policies have said, "Oh, look what's happened to free speech in society," which is, I think, very important to draw this distinction. That's a different claim than saying the First Amendment's been violated. It's a very serious thing, and actually a very worthy topic to ask: what is happening with free speech in this country? And there is an interesting issue there with content moderation. But talking about free speech as a policy category and as a value category, it's not the same thing as saying that the protections of the federal Constitution have been violated. Now, sometimes there are political figures or others who will out and out make a claim that when a company's content moderation policy results in some action that removes or frames something they've said or even removes them from the platform, they say, "Oh, this is violating my First Amendment rights." I mean, that is just a category mistake. I get the politics of it, certainly, but it's not legally an accurate thing to say.
Amy, you want to go next or should I?
Whatever. Go for it, Oren.
Okay, so I think I'll, follow Bobby's lead by trying to be a little bit provocative to stir up things. So my answer will be as follows. So the question was, does the First Amendment apply to private speech intermediaries or platforms on the internet? My basic answer, well, it probably should, but it's unlikely to happen. So the probably should is the provocative part, right? Why am I saying it probably should? Well, because we basically live in, as far as free speech is concerned, under Google and Facebook rule. It turns out that in many contexts, at least in places like the US, right? I'm not talking about China or the Saudi Arabia, where the government does intervene with a much heavier hand in direct censorship. Intermediaries, platforms like Facebook or Google have much more influence on who and what could speak effectively and what will be heard effectively than most governments in the world, and they really make the rules. So I could give you many examples how they make the rules. But basically, they make the rules and have a lot of influence, basically with almost zero formal responsibility. So not long ago, Rebecca Tashnet at Harvard published a piece on this, which was called power without responsibility, which is exactly about that. Basically saying those entities live in the best possible universe that you can imagine because they have all the power and none of the responsibility. So just very quickly to translate to legal terms, are those entities ever responsible for something bad that happens speech-wise on their platforms? No, generally speaking. Under the Communication Decency Act 230, they almost never count as speakers and therefore they're not responsible for anything. Are they subject to First Amendment rights when they not violate, well, there aren't anyways, but when they restrict the speech of potential users on their systems? No, for reasons just described by Bobby. There's something which is called the state action doctrine, and they're private entities. They're not engaged in state action. Finally, what happens if governments want to regulate those entities, even for reasons of trying to enhance speech? Can government do that? Well, for the most part, no. And even to the extent that those entities, as Bobby has implied, actually have constitutional immunity, being treated as speakers themselves with regard to what's going on their system, with a huge, of course, tension with the first set of rules, which is those are not speakers, therefore they're not responsible for anything. So the best of all possible universes, all the power, no responsibility whatsoever. Now, I've been going on for too long. I'll just say, I actually agree with Bobby. It's very unlikely that we'll see constitutional First Amendment rights applied against those entities anytime soon because state action doctrine is so entrenched. And, you know, there are some repressed lines in American constitutional law that if we really wanted to revive Shelley versus Kramer and, you know, the shopping mall cases, if we really wanted to revive, one could go there. It's really unlikely. And to the extent we've seen any attempt, and, you know, there's the perennial attempt. Every 2 years, somebody tries to assert a case like that against Facebook or Google or whatnot. I think the latest case was Prager University against YouTube, i.e. Google, and the court just throws them out because of state action. So it's very unlikely. So what could be done in reality, what's a little bit, although not very likely, I would say that instead of trying to apply constitutional right directly against those entities, what is a little bit, you know, more plausible, although there are very high barriers as well, is to remove the barriers from government when government tries to regulate those entities in order to encourage and facilitate speech, at least not make it so hard for government to do that. And that in itself will involve, you know, very complicated issues in first speech law, among other things, the treatment of those entities as speakers for purposes of the First Amendment that give them First Amendment immunity, the very early on decision that was made in Reno versus the ACLU to treat those entities like print outlets, like newspapers rather than broadcast. All of those are huge barriers, but maybe there's something to work with.
Yeah, I'll pick up there and say that, you know, I think if we think fundamentally about, you know, the First Amendment as protecting minority voices from government power, right? And we think about this dynamic of power, there's certainly a strong argument that the power has shifted to these platforms in terms of where our democratic discourse is taking place, right? And so I agree. I don't think it's likely that we'll see the First Amendment apply to private actors. But I do think, as Oren points out, there's a really strong argument that the government can exact certain types of cooperation from these platforms in the same way that the government exacts certain behaviors from broadcasters, right? Broadcasters use the public spectrum and the public airwaves. And as a result, we do see content regulation on the broadcast networks. We do see indecency regulation. We do see, you know, the safe harbor being created to channel indecent speech into certain time periods. And so I think fundamentally the decision in Reno versus ACLU, which, I mean, you have to think this is 1997 when the Supreme Court is deciding this case. The findings of fact are hilarious in this case because you're introducing technology to the court that many of them don't fully understand, right? And so that initial sort of hands-off, we're going to treat the internet like print, I don't necessarily think that's precedent that we have to honor necessarily going forward. I think there are strong justifications that the decision that was made in 1997 could never have foreseen what we've got happening today. And if we think about that balance of power, if we think about the equity and social justice issues we're facing in this country, I think there are potentially strong arguments for applying the First Amendment to private actors. I don't think I'll see it in my lifetime.
I think that's a really interesting point, and something that Professor Bracha and Professor Sanders, you both brought up was, what should we be sort of thinking about or looking at in terms of, protecting freedom of expression on social media. Professor Chesney, if you don't mind, your take on that. If freedom of expression is something that we do want to protect, and if the First Amendment won't go there, then what can be done about it?
So first I think let's define the potential policy problem we're looking to solve here. So the premise of the question is that there's a threat to speech that people in some unfair sense, in some way that's incompatible with the deeper values of the First Amendment, which, as Amy summarized them earlier, are at least at their core about protecting the speech of those the government might disfavor, right? So that the libertarian perspective on it. So the premise would have to be that we have a problem where major platforms are acting inconsistently with that. We're hearing a lot, that claim's made a lot over the past couple of years, and I don't think the facts very often bear out those claims. I think very often it's a fact-free claim that makes it look like what is in fact enforcement of content moderation policies against fraud, against false statements on material matters, sometimes statements involving incitement and so forth, things that implicate other values. So let me step are being protected. So I'm challenging the premise that there's a problem to be solved. Even if there is a degree of problem here, and I'll grant that there's certainly some degree, there's always some degree of this risk, and so there's some of this. There are contending forces at work here in the information ecosystem that what we're trying to do is tailor the best set of rules that'll be flexible to keep up with the rapidly evolving ecosystem of platforms and ways we're communicating, so as to suit a bunch of values that we're wrestling over in a deeply pluralistic and increasingly divided society. No problem. So on one hand, you've got things that I think are incredibly important. Values are incredibly important that frankly seem like they're under a lot of stress and maybe don't have as much adherence as they used to, which are the free speech traditional values. On the other hand, we have plenty of practical evidence that the platforms are capable, there are pathologies of information circulation and belief and disinformation that can result in really dramatic real world harm. I look at how the bigger platforms have been evolving, and what I see is in response to market pressure, political pressure, specifically in the form of fear of what legislators here or in other parts of the world are going to do to them if they don't get in front of it. Those two things, a little bit of litigation pressure, though, as you guys said, that tends to fall apart. But mainly the political fears and the market pressures, and maybe a little bit of front office ideological commitment as well. That's a shifting thing. I see over time, over the past 10 years, extraordinary change in the direction of having more engaged filtering. And that's partly why you're now starting to hear all this pushback from the protect speech side, because there's been such a response to the mitigate the harms side. For me, there's no chance that any of us are ever going to all agree on what the right balance is, even at the abstract level of how do you name and weight the hierarchy of values. And so there's zero chance we're then going to get it right in the particulars of how exactly you're going to frame your content moderation policy. And so we need to set aside utopian visions of a perfect outcome and think instead about whether it seems like the trend line is such that we're going to get over time, in the majority of cases, the right balance. And if we see some gaping holes where the companies seem not to be responding to the pressures in the right way, or are over responding in a way that's crushing free speech values, then we need to think, all right, where can we nudge, or maybe even be more heavy-handed? Personally, I don't think we're at the stage where it's clear that it's not okay to leave this to the market. And the market here includes the shadow of legislation too. It's not just a free market. It seems like it's adapting pretty rapidly considering the circumstances. And so I don't see it as a problem to be solved.
Okay, I think we sort of assigned ourselves roles, so I'll try to stick to those roles because it makes it more fun. By the way, Kyle, I don't know if it's okay with you, but as far as I'm concerned, people should be free to ask questions or intervene. I think that would be nice.
That is absolutely just fine. By the way, if anybody has any questions, if you would like to send them via text, you can use the chat function, or I believe you can raise your hand on here to jump in, and we can accommodate that just fine.
Yeah, great. So again, as I said, let me stick to the script we've assigned ourselves somewhat. And I just want to add 2 layers to the discussion, I suppose, partly in reaction to Bobby's nice points. The first one is the issue of the veil of ignorance, or whether we actually know what's going on and whether there's a reason to be concerned or not. Because since those entities basically, at least formally, don't owe anything to anybody, they also don't owe to tell us what exactly they're doing about those issues. So much of it remains under the hood. We just don't know. Now, of course, Google publishes something which is called the Transparency Report. It's been a while since I looked at it. I can tell you last time I looked, it was very non-transparent. They can just basically do whatever they want to and not tell us what they're doing. So it's kind of hard to judge. They don't even have that duty of transparency with respect to restricting speech on the basis of what considerations exactly. Although again, Google is trying to maneuver with the transparency issue. So that's an additional layer to the discussion. The second issue is, of course, who gets to decide, not what the right balance is, but who gets to decide what the right balance is, right? So for purposes of the discussion, let's assume that Google and Facebook got it exactly right at the moment. There is a balance to be struck, no doubt about that. The real question is, why are those entities the ones who get to decide given the gravity in the world? And again, it's not like some minor corporation deciding on their own private policy. They decide with respect to a huge chunk of speech in the world. Why is it exactly Google or Facebook that gets to decide what the rules are? So that's what I meant when I said we live under Google and Facebook rule. They decide what is basically the rules of our society with respect to the balance of free speech and other important values. And I'm not sure why it should be the case that they decide. Let me just give you a very quick anecdote to demonstrate what I'm talking about. So the other year I taught in the summer in Israel, in Tel Aviv, a course, as it happens, about free speech and digital technology. And my TA was this great graduate student. In Tel Aviv, they have graduate students in law. And he was already doing his internship with the DA or the Israel DA or whatever the equivalent of that job is. And you know what his expertise was which area of the law? His expertise was standard policies of Google and Facebook. He was working for the government, and that was his area of the law because his job was basically to beg. Okay, whenever the government wanted one way or the other. Now, I don't want to represent that the government only wanted to protect free speech, as Bobby implied. Governments often pull in the opposite direction. But basically, his job was to know what is the standard policy, right, of Google and Facebook that for almost every practical purpose became the law. And he would have to argue for Google and Facebook in the name of the state of Israel, why under their own policies they should do X or Y. Which brings me back to the question, since when exactly Google or Facebook became, the legislatures or the constitutional conventions of any country in the world?
Sorry, Amy, can I jump in and just ask a provocative question? Who appointed the Washington Post and the New York Times to make the decisions they make, or the broadcast channels, even though they were subject to regulation? Who put Walter Cronkite in charge of so much? Is that distinguishable?
That's a great prelude for Amy, because I have the hunch she would want to speak about that and the distinction between print, perhaps, and maybe even broadcast media and those kinds of media. So I'll give her the stage.
So I'm going to take issue with what Oren said, and this notion that they decide, because in reality, we decide, right? I'm going to go back to Bobby's market forces argument for a moment. And my prime example for you is MySpace, right? You may remember that there used to be a social platform called MySpace. There are many used to be social platforms that for whatever reason, people have stopped supporting. And in the same way that, we have switched from supporting the 3 broadcast networks and watching nightly television news every night to getting our news in other formats. And so in reality, does it require collective action? Can that be a challenge? Absolutely. But I think that simply saying that we've let them decide takes away our human autonomy to some extent. In saying, that now that you're on Facebook, you can't choose to leave, or now that you're on Twitter, you can't choose to leave. You can certainly choose to leave. You could certainly choose to develop a rival platform. Look how quickly we saw Parler come into the mainstream when people were concerned about Twitter deplatforming voices. We have choice as consumers.
May I? Great. So now we have some interesting cracks in our former uniform front. So here's a quick reaction. First of all, I would answer to that. Then, Amy, you should be pretty happy. You should agree with Bobby, who said, the market forces, those entities don't do whatever the hell they want. There's market discipline. We should be content with that. Why do you want, to regulate them or subject them to any rules? The market will take care of it, in other words. Now, so you should say that. And here's a partial comeback to that, I guess. Since when exactly do we entrust the First Amendment to the market? Free speech is something that the market should decide? I thought that constitutional rights and First Amendment rights are exactly counter-majoritarian rights that should protect against massive majoritarian forces, including market forces. So I'm a bit puzzled by, transferring everything to the market, even if the market in some sense works in the economic kind of way, which I have doubts about. But even if that were the case, I think that now it becomes interesting, because now the question is, what do we understand by freedom of speech exactly? And I think that an attractive understanding of freedom of speech is some sort of, a Dworkinian idea of rights as trumps, something which is outside of majoritarian control, either the majoritarian regular political process or indeed market forces, which are not even that.
It seems to me there's a risk, more than a risk, a likelihood that in order to act in any way that's effective through government power to respond to market concentrated media power requires empowering the government, which are themselves the even if we accept, which I'm not sure I do, that the First Amendment and constitutional rights are there to address the private sector actor concentration. Empowering the government in a way that will let it impact what those private sector media platforms do is what scares me most of all, vis-a-vis those particular same rights. And here I look at what's happening with the increasingly confident authoritarian competitor systems out there in the world, and the way that the ones that are surviving and prospering have all figured out that they've got to control this space. The government's got to have full visibility and full coercive power into what is and is not aired. And I think the great challenge for us is to not slip down that slope in any way. So I'll make a straight up slippery slope argument here that we must not take the first step lest we wind up at the authoritarian bottom.
I mean, I think there's a lot of truth to what Bobby is saying, particularly when you look at the sort of global movement away from some of these democratic norms and values, particularly when you look at the role that the university that the United States has
Freudian slip.
that the United States has historically played in defending freedom of speech. I think when we think about the prospect of government regulation of private speech and private entities, I think there are tremendous international consequences that would flow from something like that happening, in terms of empowering rulers throughout the world. I mean, you look at what's happening in Eastern Europe, you look at what's happening in Turkey and Egypt and parts of the Middle East, look at what's happening in Southeast Asia, in the Philippines. It's, everyone's waiting for the US to sort of open the floodgates to government regulation, I think.
So now I'm casting the role of the person who supports authoritarian regime censorship of the internet.
Perfect.
And what I have to say to
We
that
all
is,
have a role to play, Oren.
I'm happy to play mine. As Bobby said, many of them are already doing that. And, maybe Amy is right. There are also many of them also have their eyes in the US, and what happened there might make them do more or less of that. But, many of them are doing that already. So the question is, what is best for us? What do we, whatever we stand for, should do? And certainly there is a danger. Bobby is absolutely right. If the stance we take is rather than just hands off, government, please march in and do whatever you wish, that's a very bad idea as well, right? So therefore, there's of course a role both for the legislature, but more than that for the court to play, right? With respect to what government is allowed and not allowed to do. And there's always a big temptation, as Bobby says, once the floodgates are open, there's a huge temptation for government to actually act in a censorial rather than speech facilitating role. So there's a huge preventive role for the First Amendment and courts there as well to prevent that. On the other hand, again, I'm not sure the answer is do nothing about the important power of the new speech platforms and intermediaries. So, if I had to reduce it to slogans, which middle way should we take? Well, it shouldn't be about the interests of the platforms, which is pretty much what happens right now. Remember, they're not only immunized from any constitutional rights to anybody, they get constitutional immunity from any attempt to do anything, and also immunity from any responsibility to anything that happens on the system. So it shouldn't be about their interests. On the other hand, it certainly shouldn't be about the interest of government to regulate, because then we open the floodgate to exactly the specter that Bobby is talking about. What should it be about? Well, the interest of, guess who? Users and speakers, right? We have to examine a particular government regulation through that particular prism, right? What does it do to the ability of end users to freely and in a diverse way speak at the end of the day? Is this the kind of regulation that actually facilitates that? Or is it some sort of a government attempt to divert speech in this or that direction or censor it in some way? And, I think that courts and the First Amendment jurisprudence is capable of doing that.
Do you really, Oren? Have
Yes.
you, I mean, we have the FCC. The
Mhm.
FCC's goal is to regulate in the public interest.
Mhm.
And I just want to ask, how's that working out for us?
Well, not very well in the last 30 years, just like the courts and First Amendment jurisprudence hasn't been working very well. It has been captured, not only politically, but a particular view, of what free speech is about. And, I'm kind of sorry to say it's a view that actually resonates with hands-off government. Maybe in, former decades, right? It's been the opposite, right? The FCC might have been too interventionist, some would say. For decades now, it's been the opposite. And in that sense, it hasn't been working out for us very well. But it's exactly because they basically completely internalized the approach of hands off. So the FCC became sort of the classical regulatory agency that when it comes to that particular issue is against regulation.
I mean, in part, isn't that, I mean, Bobby talked about how polarized of a society we live in. Can we agree on the public interest? Like if we think we want to regulate in the public interest, I'm not sure we can all agree on what that actually is.
Yeah, so better to leave it to Facebook and Google to decide, and the market, Those are the options, right? I mean, but remember, all the options including constitutional law. Now, of course, somebody decides constitutional law at the end of the day, and that would be the courts, including the current Supreme Court, right? And they're not very likely to do it in harmony with my views. But those are the options out there, right? Yeah. Do we have any other alternatives? It's either Google, Facebook's the market, or our, democratic institutions, including both legislatures, agencies, not both, agencies, legislatures, and courts at the end of the day. We have to choose. Those are the imperfect options with which we're stuck, basically.
I can't help thinking here about War Games, the hacker classic, where at the end, the computer finally realizes the only winning move is not to play. Put our phones down and just walk away from it all.
I think this has been a fantastic exchange, and it kind of highlights, why this is such a thorny issue. There's so many things to consider. We're left with sort of nothing but tough choices in terms of balancing, the power that different actors and entities and we as a people have and how we express it here. So, thanks for that. If it's okay with y'all, I'm going to transition to a slightly different, still thorny issue, sort of the other side of the coin. We noted, at the beginning of this past discussion that we kind of had a state action issue with, applying the First Amendment. Well, let's get rid of that state action issue and assume some state action. As you know, in front of the court right now, in front of the Supreme Court, is a case about state action concerning social media. And I'm not going to dig too far into the details of that, but just broad brushstrokes here. We have someone who was kicked off of a school-sponsored team for some comments that they made, off campus via social media. The school, kicking that person off of the team, I suppose qualifies as a state action. So we have state action in a situation like that. Where is it okay for the state to act against, an individual person for speech made online?
Well, there's a really, I'm not going to use the Minnesota word, which would be interesting. But when I was at Minnesota, the Court of Appeals there decided a really troubling case involving sort of similar circumstances to the case you're talking about, Kyle, which is the Mahoney Area School District case, right? We're going to hear oral arguments in about a month on that case. And the Court of Appeals in Minnesota, thankfully the Minnesota Supreme Court overturned the decision, but the Court of Appeals said that the University of Minnesota had a right to sanction a college student who was in a mortuary sciences program. Yes, those still exist, thank goodness. The university had a right to sanction a student in a mortuary sciences program for disrespectful comments that were made on a social platform. In large part, the comments had to do about the cadavers, had to do about how she would interact inappropriately with her classmates in terms of engaging in some violent behavior. And the Court of Appeals perspective was sort of what you find in student speech cases, which is conduct that occurs off campus, whether it be on a social platform or, at the, local park or recreation fields. Conduct that happens, or speech that happens off campus, can filter onto campus in an educational institution and inhibit, right, the pedagogical environment. And as a result, the school should be able to regulate to maintain the pedagogy, right? Now, the question becomes, in that sense, is speech different than other kinds of behaviors where schools will take action against things that happen off campus, right? There are certainly cases where schools have suspended or expelled students for criminal sanctions that have, criminal conduct that has occurred off campus. Is speech different? And I think fundamentally that's the question. I'm not looking forward to what the Supreme Court has to say in this particular case. But it is the eternal question. It's the question that's taking place in workplaces, right? When you engage in a certain kind of speech in your private life, can your employer take action against you? We've seen that with public school teachers and behaviors they've engaged in on social media. Yeah, I don't think we're going to like the answer that we get from the Supreme Court.
I'll take it in a different direction, not being the expert that Amy is on the school line. I will just say on that, it does make me nervous. The prospect of schools reaching well into the private lives that are formally disconnected from school activities and school roles. There are some fact patterns you occasionally hear about. You think, well, how is that the school's business? Setting that aside, a different area in which the same question arises is playing out with all the insurrection cases. I follow these indictments pretty closely in my guise as a person who studies terrorism related things. And I'm especially interested in the early stages, which we're still in for all these cases. Some number of them involve prosecutions from a First Amendment perspective, what we would categorize either as true threats or incitement, but where the fact patterns, it'll be very interesting to see how this gets litigated when eventually someone moves to dismiss these charges, because you have a handful of fact patterns where what people are said to have done was to have communicated a threat on the interstate wires, so a federal charge, communication of a threat of kidnapping or other violence, where the actual described content are not specific to any particular intended victim, but instead are broad calls for, fellow patriots, meet me here, bring your AR-15s, we've got to do this, we've got to fight. And setting aside everything else we might say about that sort of thing, there's a serious Brandenburg type incitement question here. And I don't think you can avoid it simply by saying, well, this is being charged as a threat, not as an incitement, but as a threat. Whatever, there's a broad public statement that happens to be done with the internet as the megaphone, or social media page as the megaphone, instead of an actual megaphone. It's still one person speaking to a group, encouraging unlawful, or in this case, maybe indirectly encouraging, maybe directly encouraging unlawful behavior. And that really goes to this question that is never really been settled. Like we treat Brandenburg like it's really settled, but it's always one of those classic examples you would point to in First Amendment doctrine and say, where's something that could change if you had a strong enough fact pattern to get people thinking of it a different way? That Brandenburg's a great example of that. So I kind of wonder if we're heading towards some reconceptualization there under the pressure of some of the current anxieties we've all very understandably got. I'm curious if others think that we're sort of in that space.
I very naively, 15 years ago, when I first started teaching in this area, said, based on decisions that were coming out of courts, you will never see the courts support an incitement case that involves social media because there's no eminence there, right? If the Brandenburg standard is imminent lawless action, and I'm sitting in my mom's basement in my pajamas, and Bobby issues a call to action, there is time to reflect on my action, right? The former prosecutor in me says there is, this classic cooling off period, and therefore the threat's not imminent. But 15 years later, I don't say that to my class anymore.
So just to go back quickly to the original question, I think I can give my answer very quickly, and then I'm afraid I'll give you an anecdote. The quick answer is, like Bobby, I'm very nervous about, aggressive extension of basically governmental penalties in such context for speech especially as Amy says, speech that happens outside of the school context itself, especially when it is itself not criminal. So I think individuals should have a very strong protected sphere of speech, even controversial and problematic speech. So I am very nervous about that. Now, the anecdote is sort of only indirectly related to free speech, but you'll see why I'm giving it. It involves, I think, my second year in the US and still getting used to a lot of your strange practices. And I watched the news, and one strange practice is, of course, they speak about not college, but high school football in the news, right? And then what they actually show is this highly amusing episode where the mascot is on the field, and two teenagers, force their way into the field, and they start chasing the mascot around. And it's very funny, and you might debate whether that's speech or not, or whatever. And I find it hilarious. And then it's the end of the story, and the guy actually says, and then the police arrived, and they got arrested, and they will be charged with this and that. And I thought, seriously? Like, the land of the free? You're insane. I mean, sure. Maybe those guys should be disciplined, but really? So that's my anecdote about it.
Love it.
Well, thank you all so much for that also. That would, super, super enlightening, super interesting just to think about, sort of what the government can and can't do in relation to disciplining, students, for example, over social media. I agree with you. I'm watching that case pretty closely. I'm in a class that's on our actual little docket, so I'm really interested in the outcome of that one also. We have about 15 minutes left now, so if it's okay with everybody, I'd like to open it up a little more directly to student questions. If anybody has any questions, feel free to raise your hand. I'll recognize you, and you can just ask your question with your microphone if you like, or you can send me a chat, or you can send everybody a chat. Really, you can ask a question however you like. So I'll wait for some questions to roll in or for some hands to go up, but I did get one midway through our prior conversation, and it's just sort of a little area of regulation that we didn't really go into very much, and that's Section 230 of the Communications Decency Act. That in itself is kind of a hot button issue, just cabined within its own borders. I guess really just for everybody, what do you think about the Communications Decency Act, that particular section, and do we need to revisit it? What should be done with that? How should those companies be regulated?
I'll say something to start with because I have lots of thoughts on this one. One, I really believe that not all, but a lot of the current vogue for talking about pulling back Section 230 immunity, you will not be surprised for me to say in light of my prior comments, is motivated by a desire to create more space to pressure the companies to do things that government officials want them to do, or more to the point, to get them to stop allowing people to speak in certain ways, or to get them to stop implementing their content moderation policies in certain ways that some government officials find uncomfortable. And I think we should be very alarmed by exactly that sort of thing. That's a terrible reason to pull back from Section 230 immunity. Now, if that weren't the case, and we're just asking, is Section 230 immunity the perfect outcome? It seems to err pretty, at this point in the development of that ecosystem, it seems awfully generous. I'm in print arguing along with my amazing co-author, Danielle Citron, in our piece on deep fakes. We argued that we're focused on deep fakes, but it really applies more generally to circumstances where there is content, especially video content, but other content that appears on platform. If we begin from the premise that there is such thing as some content that is illegal, it's a sex tape, it's a deep fake that's created to in some way, defame somebody. There are various pockets where we can stipulate that in theory that is actually not in any way protected. That's tortious or criminal speech. Is there not at least space to say that a platform that even upon being given reasonable notice that it's currently carrying such content and given ample time to do something about it, and even setting the bar really high as to how clear does it have to be that this is indeed that sort of content. Is there not space to say that at a certain point, if you just say, nonetheless, screw it, we carry everything, it's not our problem, can't we say that, well, you don't get Section 230 immunity unless you have some kind of ability to respond? I mean, we could begin by saying, how about after a court decision's been rendered convicting someone or finding them liable? At that point, can we maybe agree that you have to take it down or else you're no longer immune for carrying it? There's got to be a limit there somewhere. And if we agree about that premise, now we're just negotiating on what the conditions are to attach to liability. I think there should be some sort of outer boundary policing here, not because the big platforms need it. As I said earlier, they've been moving, but because there are, as Amy pointed out, there are always going to be new platforms, including platforms that are going to try to gain market share by saying, hey, we're the place that's never going to lift a finger against you. And that's fine, except if it's conceitedly illegal content. And we ought to have some mechanism.
I mean, I'll defer to Oren on this because he's much more the IP expert than I am, but it's always struck me as ironic that, of course, the DMCA, which protects economic rights, operates on a notice and takedown standard. But the CDA, Section 230 in particular, which is supposed to protect reputational harms, emotional harms, other kinds of harms besides economic harms, we say screw notice and takedown. We'll give you all the notice you want. You still don't have to take it down. It strikes me, as Bobby says, that there has to be this balance, right? Do we really fundamentally value economic harms so much more that we create this notice and takedown mechanism to protect them? Yet all of these other harms are seemingly less important from a liability standpoint?
Okay, well, good place for me to chip in, I guess. Short reaction to Amy. First of all, as a descriptive matter, absolutely yes. That's exactly what we do, and you're not wrong. Yeah, so not only what you're describing, but also, as you know, CDA 230 expressly says this does not apply to intellectual property. Why? Because property is so much more important than protecting against defamation and sexual abuse and whatnot, because it's property. Kind of killing, of course. But of course, you know, it cuts both ways, right? That does not necessarily mean that we want to seriously change 230. You might want to say we might want to reconsider notice and takedown, or the exact contours of the regime with respect to intellectual property, and why exactly is property so much more important with respect to the balance. So it could cut both ways. Now, more generally, happily or interestingly, I find myself mostly in agreement with Bobby, I think, with both parts of what he said. So I both share his concern about, you know, giving government too much leeway by slackening the 230 immunity, but also in agreement that, yeah, there should be a line drawn somewhere when you don't get the immunity anymore. And generally speaking, you know, I can't tell you that where we are exactly right now, and I actually admit it's been a little while since I've been following the latest cases, but the general trend over a few years, maybe a decade now, was somewhat of a move away from what seemed at some point like a complete absolute immunity. So there's been a bunch of cases that started chipping, you know, at the border. It's at what beforehand seemed like an absolute immunity. And there's a good question where to draw the line exactly. So I don't know whether we're at the exact right place, but I think that's more or less where we should be. Yeah, generous immunity for good reasons, but it shouldn't be absolute or anything like that. And, you know, the details should be up for debate. Of course, you know, what I would add to that is that with a very generous immunity comes also certain responsibility with what you do on your system, and, you know, your responsibility for actually allowing speech and using that immunity for good purposes rather than bad ones.
I just got another great question, and it kind of ties in with, I think what Professor Chesney was saying a moment ago. You know, a lot of the conversation around Section 230 is you know, at least I believe, according to what you said, you know, to to find a way to increase the pressure on these companies, to sort of bend towards government policy in a number of ways and for a number of reasons. But the question that I got ties that to national security. Basically, the gist is, Mexico is considering raising fake news to a national security concern. And I do feel like that there is a national security angle to some of this stuff. What about the government's need to increase pressure on these companies to align with national security goals? How does that play in?
So I guess I'll start by the first question is disinformation in any context or in general a national security concern? I think the answer is obviously yes. It's also true that national security is a nebulous concept. The shoddy state of education across the land is at some point a national security concern. The economy is a national security concern. All sorts of stuff. The climate, you name it. The interesting question is something relevant for national security, but rather, if we frame something in national security terms, what are we trying to achieve? Are we calling for a different institution or set of institutions of the government to begin making part of their mission dealing with that problem? Are we saying that this needs a military solution, that it needs an intelligence solution, it needs the attention of prosecutors from the National Security Division rather than the Criminal Division? So we have to immediately be alert whenever that sort of framing is offered to what exactly is at stake here. Is that just a marshaling device so that more money will be budgeted to existing players in dealing with this issue to go after the problem? Is it a marshaling device to get people alarmed? And I may sound like I'm being pejorative when I say it that way, but I mentioned the deepfakes article that Danielle and I wrote. We literally did that. We literally called deepfakes a looming problem. I forget the formulation, but for individuals and for national security. And we literally tried to alarm people by saying this is potentially a national security threat. So I think it's fine to do this when it's warranted, but we then have to quickly get past that relatively easy assertion and framing and say, all right, so what now? Does that mean that is this a call for government monitoring of otherwise private spaces? Is this a call for changing who could be sued? Is it a call for creating new crimes? Is it a call for the military to be involved in dealing with it? And very often people say, well, no, I'm not saying anything like that. Okay, well then maybe we want to limit how much we talk about national security in this setting. Fine at the threshold, but let's not make that the dominant frame if you don't expect national security institutions and authorities to be brought to bear to pursue that problem. Is this stuff a national security threat? So let me apply my own test. Do we need to take some special steps to deal with this? Institutionally speaking, I think it should be clear by now. I don't think that the answer to the disinformation problems we have is for the government to get more involved as the arbiter of truth on things. And I think unless we see that the platforms in the information sphere is just flat out not responding, doesn't care, and letting these problems get worse and worse. But that's not what we're seeing with things like pandemic-related disinformation or election-related disinformation. Quite the contrary.
Yeah, so, sometimes up to the end of the 90s, basically, we used to say that what drives internet policy and internet law is basically intellectual property and porn. And then, late 90s, 9/11, we had suddenly to add national security to the list. So that nicely demonstrates the discussion here, although we haven't discussed porn, I guess, up to now. I basically, agree with Bobby. He said it better than I could. Yes, there's some stuff where it makes sense for this purpose or the other, or just on the merit to describe as a national security issue in this space. But generally, I would be somewhat concerned of characterizing this entire area as national security, and then that leading the entire discussion and what is being done in a very particular direction that I'm somewhat concerned about, which is not the direction of particularly supporting a vibrant speech sphere.
Well, I'm certainly not going to follow Bobby and Oren talking about national security, other than to say yes.
Well, fantastic. I did have one other question, and I know this one's a little bit maybe outside of the sort of the free speech realm exactly, but what about other mechanisms that could be used to address some of the same things? For example, um, the question suggested, antitrust mechanisms for dealing with some of the larger tech companies instead of, pursuing straight regulation through, for example, a repeal of Section 230. Do you have any thoughts on that?
It's interesting. In theory, one could imagine antitrust moving in that direction. Indeed, if some folks around here know something about developments, at least, not so much antitrust law in the courts or anything like that, but antitrust scholarship, there's a new wing of, young Turks scholars writing about new approaches to antitrust, which are not necessarily the old economic approaches, which are all about economic efficiency, but rather about some other values, whatever those might be. Although I don't think many of them are that focused on what was mentioned in the question. Maybe, although yes, some of them like Lina Khan, etc. So one could use, in theory, in principle, antitrust as a tool to try to move in that direction. Personally, I fear it's, well, first of all, unlikely to happen. And second, I'm not sure it would be the most effective tool for that. It's possible, right? It might be possible to shape the market in accordance of the results you want to achieve in, say, the speech space. I think given the priors of antitrust law and what it is about and what one could hope to achieve there, it's going to be the prospects are very limited of doing much with it.
I'll just say this. I'm not an antitrust scholar. I'm a little worried about the temptation that sometimes seems to manifest to see if that toolkit can be picked up and just used for novel purposes of policy entrepreneurship. It's easy to imagine that there could be anti-competitive collaboration in particular instances, and some of that's been alleged recently. So I don't mean to say that you can't have an antitrust problem. I'm suspicious of the sudden interest in this tool. And really the best one-word answer to it all is MySpace, which, as Amy said earlier, and I say this to take it beyond one word, these platforms that we've been talking about, aside from Google, I have teenagers. They don't use them. They scoff at them the way that we scoffed, or that another generation scoffed at handwritten long form letters and written in cursive. So I'm skeptical that the wheels of antitrust litigation would ever turn fast enough. Now there are some say like, oh, that's MySpace failed, but these new giants, they're locked in. I don't think so. I hate to do this. I have to run to go to another meeting. You guys continue on without me to wrap up. Thanks for including me. Bye, everybody.
Thank you,
Thank you,
Professor
Bobby.
Chesney. It was
Bye,
great to have
Bobby.
you.
Bye-bye.
Just to pick up quickly on what Bobby was saying, one of the things that I think we have to keep in mind is that many of us are approaching this from a US centric perspective, and the idea that Twitter is always going to be, or Facebook is always going to be. But we all certainly know that there are massive platforms coming out of China. There are other burgeoning platforms in other parts of the world that don't, other parts of the world that don't use Facebook, that don't use Twitter. And so, the idea that we're stuck, so to speak, with Facebook and Twitter, I think is sort of myopic, right? It's sort of stuck on being in the current moment and seeing the particular power right now. But if you go halfway across the world, you're going to see different platforms that have pretty significant power.
Although I should say very quickly, in translating from the economic question to other values we care about, the real question is not whether Facebook would still be Facebook tomorrow, but rather whether the overall pattern of very few, very dominant players, whoever the players are, is persisting or not. That's the real question, not about the identity of the dominant player, but how the market or the overall platform space looks like, which is a somewhat different question.
Well, this has been phenomenal. I know we're a couple minutes over time, so apologies for holding y'all for a couple minutes, but I just want to thank you again so much for being here, Professor Sanders, Professor Bracha, and Professor Chesney, who has since gone. This has been a phenomenal panel. I hope to have y'all back sometime to talk some more about it. Unfortunately, we've run out of time, but if you have anything that you'd like to say before we leave, feel free.
Just thank you. I always enjoy these kinds of conversations. It's sort of fun, right, to get to take on some provocative positions when you have other smart people in the room.
Yeah, same here. Thank you so much. Thank you, everybody, for coming. Thank you for the great questions. And Kyle, especially thank you for pronouncing my name in such a masterful way.
Well, thank y'all very much. Thanks, everybody, for being here. And y'all have a great rest of your day.
Bye, y'all.
Thank you.